Thank you so much, everybody, for joining us. My name is Catherine Cole. I'm a managing editor at the Harvard Journal of Law and Public Policy. And part of what we're doing this year at the Journal is launching JLPP Per Curiam, which is an online counterpart to the print edition of the Journal. And as part of our launch, we are celebrating Justice Clarence Thomas's 30th year on the court with a symposium reflecting on his contributions and those who have worked with him. And so thank you so much, Professor Mascott, for joining me today.
Thanks so much for having me. There could not be a better topic. So I'm thrilled to be able to honor one of my favorite people, great American, Justice Thomas, and his service, which I think just has been just uniquely principled and rich on the Supreme Court. So thanks so much for doing this and for including all of us.
I agree completely. I'm excited too. Let me introduce you for those who do not know you already. Jennifer Mascott is an assistant professor of law at the Antonin Scalia Law School. She's also the co-executive director of the C. Boyd and Gray Center for the Study of the Administrative State at the same law school. But she recently took a detour out of academia. She was at the Department of Justice from 2019 to 2021, where she served as both the Associate Deputy Attorney General and also worked in the Office of Legal Counsel as Deputy Assistant Attorney General. Before that, she has two prime clerkships on her resume. She worked for then Judge Brett Kavanaugh and then, of course, Justice Clarence Thomas. And all of this is after graduating top of her class at George Washington University. So I think we'll kick things off with your time with Justice Thomas. Maybe you can tell us what was your favorite memory from your year clerking with him?
Well, one of the things that sticks out in my mind, and if you talk to a number of Thomas clerks, they might many of them might mention this memory, is that the justice, generally speaking, really likes to spend time with his clerks. He loves to spend time with people. And one special thing that he holds out for the end of the term is a great trip to Gettysburg, and he takes all of the clerks from that term on his big bus, which he and Mrs. Thomas use to travel around the country when he's not having to be in Washington in court sessions. And he takes everybody up to Gettysburg for the day and has a fantastic tour guide there who takes us around to the various battle sites. And I think what's really special about that is that you get a sense of Justice Thomas's principles and his service and his jurisprudence connected back to Justice Thomas, the man, the person, the American, the one who grew up, in Georgia under segregation. And you see how personal it is to him, just the way in which freedom and liberty has grown in consistency in this country over the years, starting with the Civil War and then later not being fully effectuated until, later in the 20th century. And obviously, we're still working to make sure that we all treat others the way we like to be treated. But you see how I think his background connects with the importance that he places in the court on making sure that government in general stays within the confines that it's been authorized to operate within under the Constitution. And so constantly himself re-examining, reading, urging clerks to do so, always asking the question, how did we get here? Peeling things back. We're not just going to go with the latest thing that was said anywhere, like by the Supreme Court, in the news media, by a law professor, in a brief. We're going to go back to the beginning and look at all the sources and try to figure out what is the right answer, and then figure out how that right answer is going to be filtered through the precise question that the litigants are asking the court to examine.
Do you think that same approach has stuck with you? How has your experience clerking for Justice Thomas impacted the way you've approached your career since your clerkship?
So for me, the biggest impact has really been just foundational character traits that I think he emphasized and really embodied during the clerkship year. So I think of Justice Thomas as really embodying humility, teamwork, and loyalty and excellence. And so I certainly fall short of that a lot, but just trying to bring sort of a sense of wonder and awe to whatever legal text is being examined, and a sense of trying to be, transparent and honest, and not come in assuming that, I always necessarily have the right answer, or the right answer is what the most popular answer is. And then also in terms of approaching colleagues, one thing that is just really, really core and key to Justice Thomas and how he operates his chambers is people being supportive of each other. And so if you talk to some of his clerks enough, you'll find that one thing that makes his work in his chambers particularly rewarding, but also sometimes time consuming, is that he really wants the clerks to collaborate quite a lot with each other in the course of each case. So, sometimes in books written about the Supreme Court over the past century, you might hear about different clerks along the way with different justices where there's intrigue or trying to persuade a justice to change his or her mind, or run around with the clerks and form little groups. And that is totally not what happens in the Thomas chambers. I'm sure there are many folks who are like this and consistently good team players on the court. And we actually had quite a great clerk class across the court, people who I'm friends with and who are supporters from justices all across the spectrum. So I think we had a great year overall. But with Justice Thomas in particular, the clerks all really have to get involved in every case, particularly anytime he's writing an opinion. And in doing a little bit of research for this, I happened upon a Law 60 piece written about Justice Thomas at the end of the OT 2014 term, which suggested that in that term, in addition to the 8 majority opinions he wrote, which was about proportional for that year, he wrote 29 additional separate opinions. I think 20 of them were either full or partial dissents, and the piece said that was more than Justice Ginsburg, Justice Breyer, Justice Kagan, Justice Sotomayor, and Justice Kennedy had written combined that year. So there are many, many writings of Justice Thomas. He's very prolific. And the clerks all had to be involved in all of those, and basically through several rounds, essentially reach some kind of agreement that everything that was being sent on, we all thought was accurate and good and honestly answered the question. And so when it's your own work, particularly being circulated around the chambers for that many folks to sort of review and critique and have to settle on, it can be a humbling experience. And so you have to really just bring good faith to each other and good spirit and have a attitude and approach of learning. And so that kind of humility, but also excellence and care, I think has spoken to me a lot in future career, and has sort of helped me as I engage with, colleagues, whether they're ones in academia in particular, whether they're ones I agree with or ones I disagree with, is, being able to strongly disagree, but keep a spirit of good humor about it and not have that disagreement be reflected on the person, just the idea.
It's such a testament to who he is as a justice and a person. I mean, it's not in question that he's a legal titan, and yet everyone who's worked with him pretty much says it's his character, it's his principles, it's the way he treats other people. It's such a through line in the experiences of people who've clerked for him, who've interacted with him in other capacities, which is really, it's wonderful. It's heartening. It's lovely to hear that that was your experience as well.
Yeah. And I think not just with clerks, but I mean, he literally knows everybody in the building. I mean, so from whatever cleaning person would be there, who's people driving folks around, folks who are kind of there getting you from place to place, he knows everybody. He knows details about them. He knows things about their children. He honestly loves people. And so I think that emanates from him, and it sort of gives his clerks the energy and desire and vision to aspire to bring that approach to our lives on the court, and then also after that.
I would love to hear every single anecdote you've got from your time as a clerk, but I also want to draw on your expertise in administrative law, and specifically on the separation of powers, because I know you've done a lot of work in that field. What do you see as Justice Thomas's most important separation of powers opinion?
So I mean, there are obviously many, and I kind of take a broad view of separation of powers and how far that protection extends. So I would classify quite a few of his opinions, even sometimes his federalism ones, as separation of powers. So it's hard to say which one is the core, but one particular trio of opinions that that leaps out at me, and I think many folks will find as foundational over the years, is just the tear on which Justice Thomas went at the end of the 2014 term, writing about administrative law and separation of powers, and revisiting some doctrines that actually he himself had written on quite a bit in the past. And so basically in that term, Justice Thomas, and I think it was concurring opinions in each of these cases, but he revisited the Auer doctrine of whether there needs to be judicial deference to an agency's interpretation of its own regulations. He called on folks to revisit the Chevron doctrine of deference, judicial deference to agency interpretations of statutes. And he also wrote a very lengthy opinion in the Amtrak case, revisiting the issue of delegation and whether it actually improperly interferes with congressional power to legislate if Congress enacts statutes that are so broad that they give administrative agencies insufficient guidance when they make policies. And so the doctrine of the court has been that it's fine for Congress to legislate broadly so long as it provides an intelligible principle of some kind for the executive branch to follow. And in reality, only during the New Deal with FDR did the court ever step in and say, no, Congress has gone too far here. And so it's not a doctrine that's enforced really that frequently. And so Justice Thomas was sort of re-examining whether we've settled on the right place. And so what I think is very intriguing about that term is that all three opinions came out in quite depth within a very short span of each other, maybe over a 2 to 3 month period of time. And then second, particularly with the question about Chevron deference, Justice Thomas was really, I think, in that moment, re-examining doctrines he had previously adhered to himself. So he's very famously wrote an opinion in the Brand X decision, which suggested that Chevron deference was so sacrosanct, basically, that it could even in certain times an agency interpretation of a statute trump prior judicial precedent on interpreting the same statute. And so to kind of be willing to re-examine that and explain why 10 or 11 years later, I think was pretty telling of his desire to sort of never settle and always get things right. And one last thing I'll say about this is, I also like drawing attention to this because I think, since he's come on the court, Justice Gorsuch in particular has not only written, but gone out publicly and talked a lot about delegation. And so sometimes I think because whether it's through questions on the bench or whatever else, Justice Thomas maybe hasn't been out and about on that as much. I think, people who have just sort of entered the scene the last 5 or so years tend to think of Justice Gorsuch as really the one hammering on those issues, also probably because he had confirmation hearings that everybody watched where he talked about it. But really, Justice Thomas in 2015 wrote a lot about it. And then if you look even further back, as far as 2001 in the American trucking case dealing with EPA, he was writing separately from his dear friend Justice Scalia to say, hey, we've got to take a look at this. And so for, 2 decades or more, he's been a leader on that particular issue. And it's wonderful to see it gaining more traction and discussion on the court.
That's fascinating because I think you're right. The cases in 2014 are in some ways the seeds of where administrative law conversation about the non-delegation doctrine has gone over the past decade. And you're right. I mean, it's an interesting time to be teaching administrative law. I'd imagine so much of it is up in the air. And a lot of that you could trace back to the work that Justice Thomas did kind of in the trenches, so to speak. You mentioned, and this is, I would be fascinated to hear this from your point of view, since you teach at the Antonin Scalia Law School. You mentioned that sometimes Justices Thomas and Scalia came out on different sides of these things. While certainly they agreed on a great deal, how would you characterize the difference in their views of the separation of powers?
Well, first, since you mentioned it, I have to say, I could not be more proud than to be a law professor at the Antonin Scalia Law School that bears Justice Scalia's name. We consider it a very proud tradition and honor here and love it and love to be teaching students and educating them with that perspective of always trying to go back and re-examine and look honestly for the right answer and things. And I think with Justice Scalia and Justice Thomas, the other thing to keep in mind, they were very, very good friends, and Justice Thomas really honors Justice Scalia's memory. And in so many things, particularly their fidelity to originalism, they were right on the same page. But I think they also publicly talked about differences. So one key difference is that, at least how they talked about themselves, Justice Scalia, I think, would tell you or would say publicly that he sometimes maybe wasn't as willing to revisit precedent as Justice Thomas. Justice Thomas, I wouldn't say revisits precedent or blows past stare decisis in many cases, because he also very much is guided by the question presented in a particular case. So where he might think an area of the law is wrong, he also takes a modest role to just answering the question before him. But I think generally his approach to stare decisis, he would be willing to go further back than Justice Scalia. On separation of powers, I think one big difference does come in this area of delegation, where Justice Scalia, and you can really get this if you read Justice Scalia's dissenting opinion in the Stretta case dealing with the sentencing guidelines, where he found there to be a problem, but on a different a different ground than others might. And he really conceived of basically, I mean, he conceived of executive power, legislative power, judicial power, obviously as being different and from each other and needing to be well defined. But he would explain it, at least in some of his writings, as, once the president or the executive branch gets the powers assigned to do the task, then that's executive power, and that's the exercise of executive power. And I think for folks who are taking a closer look at the delegation doctrine, there's a slightly different approach, where maybe the view is more that executive power versus legislative power has its own internal objective meaning and content, and that legislative power doesn't just shift and become executive power if discretion is delegated to executive agencies. But legislative power could mean something that's so broad that you're actually creating new requirements on private parties. And if you take that view, then you would lean more towards the Thomas Gorsuch line of feeling like Congress can't empower the executive to do that thing. Whereas I think Justice Scalia was more willing to say, once it's given over to the executive, then the executive just has to make sure that he or she is operating within the procedural constraints, and it's really the exercise of executive power. And so it'd be interesting to see if Justice Scalia were still with us, I think, now that Justice Gorsuch is on the bench, whether there would be continue to be ongoing conversations, because he did, Justice Scalia, toward the end of his career, express willingness to revisit things like hour deference for agencies. And so it'd be fascinating to know if there'd be any budging or reconceiving, particularly as Congress is legislating less and less on, where we need to fall with the delegation doctrine.
I have one final question for you. What do you think will be Justice Thomas's greatest legacy in this area of the law?
I mean, I think his greatest legacy in this area of the law, separation of powers, will probably be his willingness to revisit delegation. I mean, I think many people looking at federal government now, particularly with the recent change in administration, it's very clear that it's so important for Congress to be doing more legislating and guiding in sort of an entrenched way through enacted law, and not leaving so much up to the executive and administrative agencies, which can shift and change then properly. I mean, policy-wise, things change. When the executive comes in, he or she needs to guide in a way that the electorate's told him or her to guide. But it really should be cabined much more by lawmaking in a limited way. And so I think with delegation, that will be talking about that, refocusing on that, that will be his greatest legacy there. And I think that will be in conjunction, I hope, with his legacy in the Lopez case a couple decades ago, at urging us to also revisit the scope of Commerce Clause authority, because it's challenging for Congress and the executive to reach a right balance when the federal government, I think, is taking too large of a role across the board. And so I think the Commerce Clause plus delegation jurisprudence of Justice Thomas will really stand the test of time for decades and centuries to come.
Yes, and hopefully it will be many years before we even have to contemplate what his greatest legacy will be.
Exactly.
It will be yet to come.
Many years yet to come.
Yes, exactly. Well, thank you so much, Professor Mascott. I think one of the takeaways is that everyone at Antonin Scalia Law School should sign up for your ad law seminars. It's great to hear your thoughts on all of this. So thank you so much for joining us today.
Thank you for having me.
Thank you.